Good afternoon, good morning to those dialing in from Europe. My name is Mariel Dinsey and I'm one of the co-chairs of HK45. HK45 is very pleased to present this event today with our HK45 Regional Ambassador, Lars Markert. Lars is a foreign law partner at Nishimura and Asahi based in Tokyo, Japan. He's a German qualified lawyer, which is where I got to know him, and he's been based in Japan since 2018. He regularly sits as arbitrator. He is, among other things, an investment arbitration expert. And pertinently for this panel, he's an expert on many Asian jurisdictions, including, of course, Japan. Our panel today focuses on developments in emergency and interim relief, with a focus on Japan, Korea, and Hong Kong, three very interesting jurisdictions at the moment. We are very fortunate to have three rising stars in their respective jurisdictions on our panel today. I'll leave it to Lars to introduce them, but before I do, allow me just a couple of words about HK45. As most of you probably know, this is the HKIAC's group for the young and young at heart arbitration practitioners. We are very active in Hong Kong and in the APAC region generally, and we're represented around the world with our network of wonderful regional ambassadors, including, of course, Lars. Membership is open to all, it's free, and we encourage everyone to join who is not already a member. If you need details on membership, it's available on the HK45 website, and we do ask that you please follow us on LinkedIn as well. Thank you for watching and for listening in. I'm looking forward to a very interesting and interactive panel, and I'll hand the rest over to Lars.
Thank you very much for the kind introduction, Mariel. I have the pleasure of introducing our speakers, and I'll do so in the order of their speaking. So we'll start with Kyunghwa Chung. She's an off-counsel at Covington and Burling's International Arbitration Practice Group, and in doing so represents both states and corporate clients in complex international disputes. When doing so, she draws upon her expertise in public, international law, investment, and trade law. And she has represented clients in international arbitrations under the rules of HKIAC, ICC, SIC, KCB, JCA, ICSID, and UNCITRAL. Kyunghwa is dual qualified in Korea and New York. And Kyunghwa will address the topic of interim measures before an arbitral tribunal has been constituted. So quite an interesting topic. She will be followed by Yoko Maeda. Yoko Maeda is a partner at City Yuwa Partners in Tokyo, Japan. And Yoko serves as an ICC Court of Arbitration member from Japan and is listed on various arbitrator panels of various arbitral institutions. She practices as counsel across a wide spectrum of matters under the arbitration rules of, again, HKIAC, of course, ICC, JCA, SIAC, ICDR, and VIAC. And last but not least, we have Suraj Sajnani, who is an associate in the dispute resolution team of King & Wood Mallesons Hong Kong. And he's specializing in international commercial arbitration and Hong Kong litigation. And he is also close to HK45. He's a member of the HK45 committee. Suraj is qualified in both Hong Kong and England and Wales. And he has successfully acted for clients, and what's probably pertinent for today, particularly with respect to numerous urgent asset preservation and recovery applications in both courts and arbitrations. And what I forgot to say for Yoko will deal with interim measures after an arbitral tribunal has been constituted, and Suraj will tackle enforcement of interim measures, particularly when dealing with mainland China. Now, you've probably seen on our invitation that we try to make this seminar as interactive as possible. So please feel free to make use of the Q&A function that we have and send in your questions to the speakers. Mariel and I will try, if time permits, to select questions and put them to our speakers. And a second thing we're trying to do is we're going to poll you. So we're going to ask you some questions before our speakers make their presentations and after, and then we see whether your opinion has changed. So let me run our first poll. And we have 3 questions for you on the screen. The first one is, would you choose Hong Kong as your arbitral seat for China-related interim measures? The second one is, would you go to an emergency arbitrator or domestic courts for interim measures before the constitution of the tribunal? And the third, and there we made it difficult because you have 3 answers to pick, has your preference for either arbitration or litigation changed as a result of COVID-19? So that's a question for those of you who were disappointed that on our invitation to the seminar, we didn't mention COVID-19 at all. So we'll wait another 10 seconds. I see so far 22 out of 26 participants have voted. So maybe we'll give you just enough time for all of you to vote. The count is going up very, very well. Okay, another 10 seconds. I think some people are still undecided. Maybe the third question was too difficult with the 3 options. Okay. We have 66% who have voted so far. And maybe that's the best we can get for now. And maybe later you have it a bit easier. So we end the poll here and show you the results. So 98% would choose Hong Kong as a seat. That's very good. And I count on Suraj to get this to 99% at least. Then we have, that's quite interesting. It's very much divided as to emergency arbitrators. So 57% would still go to domestic courts rather to an emergency arbitrator. And as for the last question, interesting to see COVID-19 would allow people to do more arbitration. Let me see if I can put this on the screen. So here's up on the screen. So let's see after our talks what the change in opinion is. We'll be curious. Okay, with that ends our first poll, and I think I can hand it over to Kyunghwa, please.
Thank you, Lars. Good afternoon to everyone in the Asia, and good morning to people joining from Europe. My name is Kyunghwa Chung, and I'm with Covington & Burling. And thank you, Lars and Marielle, for your kind introduction, and many thanks to HK45 for inviting me to speak at this webinar. In this webinar, I would like to introduce emergency arbitrator proceedings, which is an interim measure mechanism used before the constitution of the arbitral tribunal. First, I will provide you with an overview of the emergency arbitration, and then a comparison between court-ordered measures and emergency measures. And lastly, I will briefly discuss emergency arbitration in investor-state disputes, which is a new development in this area. Now that I see the results of the poll, it makes me a bit nervous and then a bit burdensome to change the minds of my audience here today. I'm sure the results will change after my presentation. So the emergency arbitrator is a person appointed to grant emergency relief pending the constitution of an arbitral tribunal. When a party is in need of interim or conservatory measures, it has the option of waiting for the constitution of an arbitral tribunal or resorting to a national court. However, there are risks that in the time necessary for the constitution of the tribunal, the party may incur irreparable damage, and the appropriate court for resolving the issue might be the home court of the respondent. And this is the reason why many arbitral institutions, such as HKIAC, ICC, LCIA, JCAE, where Yoko is, KCAB, the Korean Commercial Arbitration Board, and SIAC, introduced emergency arbitrator proceedings in recent years. Under most of the arbitration rules, the application for emergency arbitration can be made even before filing a request for arbitration or notice of arbitration, the term used under the HK rules. However, some rules require that application for emergency arbitration has to be filed concurrently with the notice of arbitration. Even when you file for emergency measure before the filing of the notice of arbitration, it is usually required to file the notice of arbitration soon after the application for emergency measures. So for instance, under the HK rules, you have 7 days to file a notice of arbitration after the filing of the application for emergency measures. Otherwise, the emergency arbitration proceedings will be discontinued. The requirements for application for emergency arbitration is somewhat similar to that of application for interim measures before courts. So one has to prove irreparable damage irreparable damage or irreparable harm caused if emergency measure is not granted, and such harm substantially outweighing the harm that is likely to result to the party against whom the measure is directed, and reasonable possibility of success on the merits of the claim. Emergency arbitration proceedings proceed very quickly. And in fact, this is the strongest argument for the emergency arbitration. The time limit for the institution to appoint the emergency arbitrator is between 1 and 3 days, although it can be extended in particular circumstances. And very short time frame is allowed to emergency arbitrators to render the decision. The time frame varies from 5 to 15 days. So in a nutshell, in 15 days at maximum, you can get your decision from the emergency arbitrator. Needless to say, such a short time frame makes the lives of counsel and the emergency arbitrator not easy, as counsels have to prepare their briefs in a very over the night, and the emergency arbitrator likewise has to write its decision in a very quick time frame. And I recall the preparation for the emergency arbitration hearing being one of the most thrilling experience as a counsel preparing for a hearing, because the respondent had to prepare its responses in a couple of days, and both parties had to answer a long list of questions within 48 hours just before the hearing. But I saw the client being very, very satisfied with such expeditious proceeding. A measure issued in no later than 2 weeks would no doubt be a very useful tool for its users. And emergency arbitrators have wide discretion to decide the appropriate measure either in the form of order or an award. ICC is an exception, as it explicitly requires the emergency decision be rendered in the form of an order, which might have repercussions in the enforcement stage. However, it is very important to note that the application for interim measures before a state court remains possible, even when application for emergency arbitration is chosen. So the party's right to go to a court is not taken away by applying for the appointment of an emergency arbitrator. Then how is emergency arbitration different from court-ordered measures? First of all, a court order is available against third parties. However, emergency arbitration is not. It's only available between the parties to the arbitration agreement. A court hearing could be ex parte, so a court can render its decision without hearing from the counterparty, but the emergency arbitration rules now in force do not foresee ex parte hearings. And lastly, some mention the effectiveness of the enforcement of court orders as a difference. However, on this point, I would like to introduce that there are many national arbitration acts that ensure the enforcement of interim measures explicitly in their statutes. And Article 18-7 of the Korean Arbitration Act could be an example. Then, what are the downsides to court orders compared to interim measures by an emergency arbitrator? most importantly, confidentiality is not secured in court proceedings. And second, the object of the relief may be located in a jurisdiction where effective court assistance is not available. And also the parties might be hesitant to go to a court in the respondent's home jurisdiction, the precise reason why parties have chosen arbitration over court litigation. When the emergency arbitration was first introduced, people were quite skeptical about the enforceability of the decision, and especially when it were rendered in the form of an order as opposed to an award. However, what I witnessed from my clients and the parties around me is that the parties were quite willingly abiding by the decision, and such compliance was ensured as the parties were very concerned about the implication that the emergency decision might have on the merits proceeding. And this is one of the critical reasons why many parties nowadays are choosing emergency arbitration over court measures. As my last topic of today's presentation, I would like to introduce a new landscape, which is emergency arbitration in investor-state disputes. At present, emergency arbitrator procedure is not available under the exit arbitration rules or the ancestral arbitration rules, under which majority of the investment disputes are resolved. And in accordance with the interpretive guideline of the ICC Commission, even the ICC arbitration rules do not apply to emergency measures applied by the investors in an investor-state disputes. However, many investors started filing for emergency arbitration under the SCC, the Stockholm Chamber of Commerce arbitration rules, as they do not distinguish between commercial and investor-state disputes. So far, there have been at least 7 publicly known cases. And as more and more investors are starting to use emergency arbitration for their disputes against host states, there have been many debates about the fundamental question of whether to allow emergency arbitration in investor-state disputes. For instance, questions were raised as to whether sovereign character of a state should pose challenges to the use of emergency arbitration in investor-state disputes. And second was related to cooling off period being a hurdle in investment disputes. And third, some of the commentators raised the question that state respondents are less suited to move quickly, which is a big difference between a commercial party, a private entity. Despite all these scholarly debates, given such demand for emergency arbitration in investor-state disputes, SIAC in 2017 has launched a set of investment arbitration rules that explicitly introduced emergency arbitration to investors. This concludes my short presentation on emergency arbitration. I would like to emphasize that the primary objective of pre-arbitral measures is to help the parties to react quickly to an urgent situation before the passage of time renders any measures practically ineffective. And there is no doubt that emergency arbitration serves such purpose very well. Thank you.
Thank you very much, Kyunghwa. That was very interesting, especially then crossing over into the last part where it gets really challenging when it comes to investment arbitration. Maybe since we still have a minute left for you, you've kind of mentioned that there's a bit of debate, but what is your personal view about the use of emergency arbitration in investment arbitration? What do you think? Does it work, or is it fair to states?
Sure. My personal view is that there should be no difference in investment and commercial arbitration when it comes to the investors. And also emergency arbitration should be allowed in investor-state disputes. 3 points were raised in my presentation. One being the sovereign character, whether the sovereign character of the respondent becomes a hurdle. Second, the cooling off period, whether that becomes another hurdle. And third, whether the inherent sort of characteristic of state respondents becomes a hurdle. As to the first point, I don't think a sovereign character of a respondent should be a hurdle, because even the ICJ has recognized that interim measures, which includes emergency measures, has a binding effect over the states. And to the second point, with the cooling off period, so the opponents were arguing that in order to apply for an emergency measure, one has to comply with the cooling off period, which is a period during which parties have to settle the disputes amicably. And if that compliance is not made, if the parties do not comply with the cooling off period, then the application should not be allowed. But I think the cooling off period, the compliance with the cooling off period and the application for the emergency arbitration should be decided differently. Because the compliance with the requirement of the cooling off period should be decided by the merits tribunal, not by the emergency arbitrator. And that will be decided at a jurisdictional stage, depending on how you view the characteristics of the cooling off period. And also on the last point, in order to address the respondent state's difficulty in moving quickly, maybe for the mechanism that we institute for investor-state disputes, we may allow some more lenient time frame.
Okay, very, very comprehensive answer. For our viewers, Google Kyunghwa's name. There is a very good article to be read, just so much.
Thank you.
Okay, that brings us to our next speaker. And Yoko Maeda will address basically what happens in terms of interim measures once an arbitral tribunal has been constituted. So Yoko, the floor is yours.
Thank you, Lars. Hi, good morning, everyone, and good evening to the audience from Asian countries. My name is Yoko Maeda. I'm a Japanese lawyer. I'm a dispute resolution partner in CDO Partners, a Japanese law firm. And in my capacity as an Japanese arbitration practitioner, I'd like to introduce you today how interim measures work in arbitration in Japan. And I will also introduce how the interim measures in the court and the arbitration was affected by COVID-19. And like many other countries, Japanese arbitration law is based on ancestral model law. So it allows the court to issue any provisional orders before and after the arbitration is initiated. And a court can grant any type of interim measures that can be granted in support of litigation. And this includes provisional attachment and, interim attachment and interim injunction. And as to the interim measures after arbitration is started, there is another option, that is to seek for our arbitral tribunal's interim order. However, unlike emergency arbitrator, that is rarely discussed. And, when you talk about interim measures, discussion is always focused on, emergency arbitrator. And I myself actually hasn't, heard a lot about, how is, arbitral tribunal's interim order. But today I'd like to introduce as much as possible how is it different from emergency arbitrator, and also how is it different from the court interim measure. And talking about so going back to the court interim measure in support of an arbitration, as I said, Japanese court can grant any kind of interim measure which is available under Japanese law. But in order for Japanese court to have jurisdiction, it is a little bit complicated. So if the place of arbitration is in Japan, the court would have jurisdiction. And even if not, if the subject matter or the property to be seized is located in Japan, the court will also have jurisdiction over that case to issue an interim measure. However, there's another pattern of the case, like that is a Japanese court may have jurisdiction if the place of performance of contractual duty is in Japan. But it is not as simple as it sounds. So the place of performance of contractual duty can be multiple places, and it can sometimes it depends on interpretation. Where is the place of contractual duty? So there are several court cases as to this point, but for today's topic, I think it's too complicated, so I will not enter into detailed discussion. But another problem, another difficulty with the court interim measure is in case if the subject matter or the product, the subject property to be seized is located in multiple places, you have to go to all the different courts which have jurisdiction over that property. But in case of arbitrators' interim order, as long as that interim measure is related to that arbitration, you can simply go to the arbitrator and ask for interim measure to be issued. And the requirement for the interim measure to be issued is almost the same with emergency arbitrators case. And I would also like to talk about duration, the timeline for the interim measure, interim order to be issued. Because in Japan, I think it's quite interesting. And I'd like to introduce the case that I myself experienced. And in Japan, generally, Japanese court is very diligent and they're very smart. And however, there is one thing interesting. If there is a clear deadline for the interim measure to interim order to be issued, the court will try hard to issue an order before that deadline. However, if there is no clear deadline, but if it's urgent, sometimes the court can be very slow. So I'd like to introduce one example. Under Japanese Companies Act, there is a kind of mechanism or procedure which is called demand of sales of shares. And that is under that procedure, supermajority shareholder who holds more than 90% of the shares can force the minority shareholder to sell the shares to the supermajority shareholder. So if the supermajority shareholder sends a notice to the minority shareholder, and once the 20 days have passed from the notice, that the shares of the minority shareholder will be assumed as automatically transferred to the supermajority shareholder. And I represented the minority shareholder in one case, and we seek for interim injunction from the court to stop that procedure. And we explained to the court this order needs to be issued before the 20 days, deadline, because after that, the minority shareholder will become non-shareholder. So we will lose the standing as a party for the procedure. And in that case, the court issued the order just in 1 week. But in another case that I represented shareholder, in that case, we seek for interim injunction of to stop the directorship of the directors of the company, because the directors were so bad, and they were trying to transfer the assets of the company to another company, which is an asset holding company of those individual directors. So we seek for the court interim injunction again, and we explain to the court that this is very urgent because directors are now transferring all the important assets to the other company. But the court took time, and it took like 5 months for the court to, make a decision. So, that is a very interesting and sometimes very troublesome point of the Japanese court. And compared to that, as to the interim measure, which would be issued by the arbitral tribunal, unlike emergency arbitrator, there is no clear deadline, like 2 weeks or 15 days, like in Hong Kong HK45. There is no clear deadline in the arbitration rule, institutional arbitration rules. But my impression is that generally the tribunal will listen more to the parties, especially to the applicant, and the arbitral tribunal would be careful as to the urgency of the matter, and if the tribunal finds it's urgent, and also if there is a ground to seek for the interim order, the arbitral tribunal would render the interim order in time. And another point that I would like to point out is in Japanese court, if you'd like to seek for interim order, you have to specify in very detail in the court. So, for example, if you'd like to obtain an interim attachment against a bank account of the respondent, you have to specify not only the bank name, but also which branch does the respondent have the account. And usually, the claimant doesn't have that kind of, information. So sometimes it's very difficult to seize, the asset. And the same applies to, the real estate. You have to specify the address of the assets, and, in order to seize the asset. But in case of the interim order issued by arbitral tribunal, there is no clear rule to what extent the claimant has to specify the subject matter. So it would depend on the tribunal to what extent you are required to specify the subject matter. But depending on the arbitrator, the arbitral tribunal arbitrator could be more generous as to the claimant's obligation to specify the product. And also, this is because Japanese court is Japan is a civil law country, but in Japan, it is not possible to obtain more broader interim order, such as the tribunal's order to disclose the asset, or sometimes like freezing order. Those are not, they are simply not available in Japanese court. But in arbitral, if you seek for an interim order from the tribunal, sometimes it's possible, depending on, probably depending on where the arbitral tribunal come from, and also depending on the arbitral seat or the substantive law of the case. And I think I'm running out of time, but I'd like to also briefly, touch on the issue of how COVID-19 changed, anything, or whether it changed anything. And, talking about Japanese court, it really heavily affected by COVID-19. So except for, urgent cases like interim order case, Japanese court postponed the court hearing date indefinitely once the emergency declaration was issued by Japanese court. And as you all are aware, unlike that, all the arbitration institutions tried to encourage the arbitration procedure to continue to proceed, without delay, as much as possible once these COVID-19 things happened. And especially with regard to interim procedure, because it's urgent from the outset, even before the COVID-19 things happened, it was allowed that, it was generally accepted that hearing take place virtually, even under normal circumstances. And I found in HKIAC's website which introduces the recent experience of HKIAC to conduct virtual hearing in, I think it's about emergency arbitrator, but anyway, in interim procedure. I mean, the virtual hearing in interim procedure. So it's quite interesting. So, and talking about the interim measure, as I said, even the court didn't postpone the hearings or procedure for interim measures. I mean, Tokyo District Court. But you know, the difficulty is that the filing itself, filing of the application for interim measure was difficult in Japan because the requirement is that you have to bring the application in hard copy to the court. So you cannot send it, you cannot submit it online, or you cannot send it by email. You know, so especially under the emergency declaration situation, it's difficult for lawyer to prepare the hard copy and bring it to the court. And another impact was the staffing. As I understand it, in arbitration institutions, although the staffs were basically asked to stay home and work remotely during the under emergency situation, in Japanese court, interestingly, the court clerks were ordered to work remotely, but they couldn't work remotely because they were not given remote work circumstances, environment. So they cannot even take phones and they cannot see the emails. And they stayed home 4 days a week. So if a counsel wants to speak to, the court clerk in charge of his case, he have to wait for 4 days in the worst scenario. So that I think that caused delay, even in the interim procedure in Tokyo District Court. So I think I'm running out of time, so I try to stop here. But in general, as you can see, arbitration institutions tried much harder compared to the court to continue to function as usual even after COVID-19. And also, in general, in interim measures, even though of course the court interim measures have its own advantage. I would say the interim measures by arbitral tribunal sometimes have much more flexibility and convenient.
Okay, thank you very much, Yoko. I'm very curious how the next poll is going to end up now after we heard your presentation. We don't have a question currently in our Q&A, so I'll invite all our attendees to post questions, and so maybe we'll post a question later to Yoko. But for now, would continue with Suraj, and he will talk about the Hong Kong mainland China interim measures arrangement. So Suraj, please go ahead.
Thank you very much, Lars. Thank you, Lars and Mariel, for inviting me to speak at the webinar. It's a real pleasure and it's a real honor to be speaking on a panel with Kyunghwa and Yoko. I should probably forewarn the audience with that with both Kyunghwa and Yoko having delivered their speeches, the best part of the webinar is now behind us. But with that in mind, I will try to keep everyone entertained for a few minutes about a recent and very pertinent development in interim measures for arbitration seated in Hong Kong, and that's the interim measures arrangement between mainland China and Hong Kong. And keeping in line with our horses metaphor, like the title of this webinar, I absolutely appreciate that this particular one has been flogged over the past 18 months. So I am going to try to keep my comments as practical as possible. And I won't go into the text of the new arrangement itself, but I'll try to focus on some of the more practical tips based on my experience working on a couple of these applications and advising clients on it so far. So just before I begin, a little bit of background about me. I'm an associate in King Wood Malleson's dispute resolution team in Hong Kong. My practice is, of course, international arbitration and also Hong Kong litigation. Now, because of the platform that we have, our platform, it really gives us an opportunity to work quite a bit on China-related disputes, which is why I've been quite lucky in the short time that the arrangement has been in effect. I've acted on a few matters involving the new arrangement since it's been in force. So, and look, I appreciate that the audience that we have today, it's from a pretty global background. So I'll start with a very brief intro on the arrangement itself. Essentially, the arrangement, it was introduced in early 2019 and it came into effect in late 2019. What it does, it gives a mechanism whereby parties to Hong Kong seated arbitrations have a mechanism to apply directly to mainland courts for interim measures in the mainland, and parties to mainland seated arbitrations can apply directly to Hong Kong courts for interim measures in Hong Kong. The reason this is quite a revolutionary arrangement is that prior to the arrangement, there really was no clear mechanism for parties to foreign seated arbitrations to apply for asset preservation or evidence preservation in the mainland. On the other hand, the Hong Kong courts have had that power to grant interim measures in aid of non-Hong Kong arbitrations for quite some time. So the arrangement actually has a lot more significant impact for Hong Kong seated arbitrations applying for preservation on the mainland rather than the other way around. So of course, this immediately makes Hong Kong a very attractive place to have an arbitral seat for anyone that has a China-related dispute, because really it's now the only jurisdiction globally outside the mainland China that has this direct mechanism to go to mainland Chinese courts for interim measures. Now, the arrangement, it was introduced first in January 2019, and immediately it got a lot of attention, but it got that attention mostly from arbitration lawyers. So of course, the natural question is the hype around that arrangement actually justified? I think it is. I've gone in and looked at the statistics of the HK45 over the past 5 years, and the top 2 geographical origins of parties to HK45 cases, no surprise, number 1, Hong Kong, number 2, mainland China. So when one overlays the actual users of Hong Kong arbitration on top of the real impact that this arrangement has, you can see why there's been so much excitement around this arrangement. When it came into effect, on the 1st of October last year, 1st of October 2019. Within 10 days, we had 5 applications under the arrangement. This was announced by the HK45 very early on. And that was in October. This, FYI, was in the middle of Golden Week holidays in mainland China, and this was pre-COVID-19 when a holiday really meant everybody was out and traveling. Yet despite this, there were still 5 applications in the first 10 days. Personally, in the weeks leading up to the arrangement, I advised 3 different clients on how to deploy this particular arrangement in their subsisting Hong Kong arbitrations. And earlier this year, my team and I, we secured quite a substantial preservation order for a client. And this was the first ever order granted by the Shanghai Financial Court. Now, some of you might be familiar with that court. That court itself is actually quite interesting. It's quite new. It was founded in 2018, and it's the PRC's first specialized financial court. So very exciting decision for them to grapple with the interim measures arrangement and grant an order under it. So yeah, very exciting decision and very happy clients. Now, with that background on the arrangement, let me get into those tips that I mentioned. I want to spend the next few minutes focusing on 5 tips that I've experienced using this arrangement. So tip number 1, decide early on which court you're going to apply to, and seek specialist advice from local counsel in the place of that specific court. And I can't stress this enough. The new arrangement, it allows you to make an application to mainland courts either in the place of the respondent's residence or in the place of the subject matter of the application. So where you're trying to freeze the assets or where you're trying to freeze the evidence. So it gives you those two different options. And now it's important to really remember, China is a very, very, very big country. There are a lot of courts in the mainland, and this arrangement is really quite new. Not everybody is familiar with it just yet, so there's a learning process. And the judges that are going to be dealing with applications under the arrangement, they will want to make sure that applications are properly scrutinized, because it's going to be these first few pioneering applications that really set the procedural stage on how future applications will be processed. So having a team on the ground in the location of the court, incredibly important. For the Shanghai Financial Court application that I mentioned a little while ago, the work by our Shanghai team was absolutely invaluable. There were a number of requisitions that were raised by the court, and it's really only very close communication with the court that allowed the order to be granted in the efficiency that it was granted. So yeah, tip number one, figure out where to apply, and definitely work with a local team in the place of the application. The second tip is ensure you have mainland court compliant documents. Now we're all very familiar with notarization and legalization processes, and nobody at all is excited about them. But really don't underestimate the amount of time and the number of jurisdictions that might be involved in just getting that mainland court compliant document process sorted out. Now, let's take a really simple case. Say you've got an American bank's Hong Kong branch instructing you on a matter. It's very likely that that process is going to need coordination from US lawyers, US notaries, a Chinese embassy in the US, the Ministry of Foreign Affairs in Hong Kong lawyers, and of course, PRC lawyers to actually tell you what the specific requirements are. That's a large team, and it can get quite expensive. And most importantly, particularly for urgent applications, it can take a bit of time, particularly in the current COVID-19 climate that we have. So, and also the requirements can actually differ from court to court, but they might also differ based on the jurisdiction of the party that's applying, or the jurisdiction where the documents you're seeking to use, where those documents were created. So quite a complicated process. Do not underestimate the time that it requires, the coordination it requires. Again, an area where having PRC lawyers on the team, absolutely invaluable, because they can liaise with the relevant court ahead of the application to understand exactly what that court's requirements for the upcoming application are going to be. Tip number 3, if you're working on a HK45 arbitration, work very closely with the HK45 when making that application. What we're normally used to in the common law world is where applicants make application to the court on their own directly. In mainland China, there's a common practice that the Mainland Chinese Arbitral Institute, it helps transfer its application from the parties to the court. So for applications under the new arrangement, it really depends. And the HK45 has published a very, very helpful practical note, a practice note on their website outlining exactly the procedure you need to follow. And essentially, there are 2 outcomes. Number 1 could be where the HK45 issues a letter of acceptance and the applicant transmits the application themselves. Number 2, the full application has to be sent to the HK45, and it's the HK45 that then transmits the application onward to the court. Which of those outcomes you have to follow really depends on several factors, and the practice note by the HK45 really sets this out very well. Basically, some of the criteria to take into account is whether the arbitration's already been commenced. Now, it's important to remember that under the new arrangement, you can make applications before an arbitration is commenced. So that determines sometimes whether or not you need to have the application transmitted by the HK45. Also, whether the receiving court has indicated any practice as to how the receiving court accepts interim measures application. Again, a lot of coordination with a PRC local team. And as an aside on HKIC, I have to say, the HKIC team, it's ultra fast. It's really quite incredible. I'm very grateful to the HKIC team. Having said that, always make it easier for them to help you as well. Just like you would for an upcoming emergency arbitration, give them a heads up and try not to send your application on a Friday evening. Tip number 4, having worked on this, if you're looking to freeze assets, engage investigators. Engaging investigators in the mainland helps quite a bit. If we were to compare, say, an injunction application in Hong Kong courts, let's say a straightforward Mareva injunction application, you trundle off to court, you seek your injunction for a certain amount, but you don't necessarily need to tell the court precisely where all the money is. You would then take that injunction order and then you would go and serve it on banks that you think your target has a relationship with. It's quite different under the arrangement, because under the arrangement, it specifically says an application for preservation needs to include clear particulars of the property or evidence to be preserved, or concrete threads which may lead to a train of inquiry. This is essentially asset clues. Essentially, before you apply, you have to make sure you have some pretty clear asset clues. This is actually quite similar to what Yoko mentioned a few minutes ago about the practice in the Japanese courts. You really need to provide some asset clues in order to make that application. So under the arrangement, it would make sense to ensure you have that information or engage some investigators to help you get that information. And my last tip would be to arrange insurance as your security for the application. Now, the amount of security that an applicant needs to deposit, it really varies from case to case and court to court. Usually it's a percentage of the amount you're trying to freeze, but of course the golden question is what percentage, how much? That's really hard to answer, but and it could be as much as the entire amount that you're trying to freeze. Now that's quite different from your standard, say, Hong Kong court Mareva application, where depositing in security of the entire amount is actually quite rare. It's a percentage, but to deposit the full amount as security, that's actually quite rare. And in mainland courts, it seems like that happens with a bit more frequency. Now, the good news is that an applicant can actually buy a guarantee from a local insurance company, but of course that guarantee will cost. Now, using a guarantee, it's much more common, particularly for high value disputes, and particularly bearing in mind that eventually when you want to export money out of mainland China, if it's a large amount, you might trigger safe restrictions. So the guarantee sometimes is the better way to go. For context, in an application that I did some time ago, the amount being frozen was a number of billions, and the guarantee amount was a number of millions. Now, of course, as a percentage, it's not that high, but it's still a large amount of dollars. So it is really important to make sure your client is forewarned about this. They've made arrangements for this, and really work in some time in your work stream to arrange that guarantee as well. So that's my race through my personal 5 tips in dealing with the new arrangement. Definitely a space that's going to be evolving a lot more. Definitely an area that we're going to see a lot of attention in. So yeah, thank you very much for giving me the chance.
Thank you very much, Suraj. That's really an interesting new topic. Actually, I've learned a lot as well. I think Marielle actually will give us an update later on the latest numbers of the HKIC that has handled. I would still want to go back to Yoko once more with one question that came up. And that was Yoko has presented basically an advantage over saying like arbitral tribunals are more flexible in the orders they issue than Japanese courts. And my question would just be, once the tribunal orders such a more flexible decision, is there any difficulty then to have that enforced in Japan?
Yes, thank you, Lars. So basically, and like many other countries, Japanese court doesn't enforce like interim orders, which is issued by arbitral tribunal. So if you think about enforcement, it makes much more sense to go to Japanese court, because only the interim interim orders that is issued by the court can be, for example, recorded in a real estate record, or it can be claimed against third parties. So in that sense, yes, court, the interim measures, interim order which is issued by the court would be more strong, would be stronger, I mean.
Okay, just so we make our poll a bit more fair. I see we're almost running out of time, so let's run our poll once more. Let's see whether anything has changed. Let me see. I'm going to relaunch the polling. I hope that works. So you see the questions up once more. You're invited to vote. So far, looking very good for Suraj. We got 100%.
I'm very nervous, Lars, because starting at 98, it's quite hard to beat that.
Indeed, but I think what you told us was very interesting. So we have 30% who voted. I'll share the poll in a second, the results. Still looking good for Suraj, I can tell. The emergency arbitrator, yeah. Kyunga, we'll have to see how that went. And the answers about COVID-19, they also seem to be similar as last time. So I would leave the poll open for another 10 seconds. We have about 60% who have voted. Okay. Now a couple of more.
Do I have to put in like 3 seconds of another talk or something?
You might have to. We'll take a look in a second. Okay, maybe we'll end the polling here because we're running short on time. Stop the poll here, and I'm sharing the results. We're going to take a look. So,
oh, okay. More efforts.
Yeah, 100%. Kyunghwa, I think you kept it about level. Maybe some people were not fully agreeable with the use in investment arbitration. I don't know. And I think we have a little bit more people that said no, the preference hasn't changed, and a little bit less people that say yes, we need more arbitration. That also might have to do with the fact that our attendance has slightly changed. There were more people that joined, so there might be a bit of a slightly different crowd that have addressed that poll. So thank you very much. I hope that made it a bit interesting. I'm going to hand over to Marielle for some closing remarks.
Thanks, Lars. Just very quickly on the on Suraj's topic on the Hong Kong PRC interim measures arrangement. The statistics from the HKIAC are that HKIAC has handled 24 applications worth over US $1 million. The mainland courts have made court orders in respect of those applications to a value of $700 million US to date. And in 25% of those applications, the applicant was from mainland China. So just to round that out with some very current statistics from the HKIAC. Just very quickly, we've received one question with respect to the impact of the security law on arbitration. Since this is slightly away from the specific topic of today's webinar, we'd refer you to the HKIAC website. There was a release made on the 29th of June entitled Hong Kong Remains a Neutral and Effective Seat, and that contains all the information you need to know. Thank you very much to all of our panelists. It was a very interesting discussion today. Thank you very much also to Lars for moderating. I hope our audience is more clued in on the various possibilities in the East Asian region, as I'll call it. And we look forward to seeing you at one of the HK45 webinars again soon. Thank you very much for listening.
Thank you, everyone. Bye-bye.
Thank you.
Thank
Bye.
you.
Bye.